Once again, it's my privilege to welcome everyone to this Wallace Stegner Center event here at the S.J. Quinney College of Law. We're very privileged to have with us today former Senator Jeff Bingaman from New Mexico. I'll introduce him in just a couple of seconds. I believe a sign-up sheet is being passed around. It helps us stay in touch with folks, so please sign up when it comes through. Cell phones off if you don't mind. And I also would like to thank our donor who has supported today's presentation, the Cultural Vision Fund, which in addition to supporting our lecture series also supports the Stegner Center's Young Scholar Program, as well as our annual symposium, and they have been with us as a supporter for 15 to 20 years now, and we're deeply indebted to the Cultural Vision Fund for their support. I also should note that this is the final open public event for this school year for the Stegner Center. However, there is one other event coming up on Friday, May 3rd that may be of interest to some of you in the room. The Stegner Center is co-sponsoring a half-day conference on conservation easements and federal tax law. And registration is required for that. You can get more information off of our website. This is an area of law that is of interest to you. Certainly conservation easement practice is becoming a vitally important part of natural resource law, and in particular for purposes of conservation of nature. With that, let me introduce Senator Bingaman, who grew up in southwestern New Mexico, the child of teachers. His father was a chemistry professor at Western New Mexico University. His mother taught in the public schools. After Jeff graduated from Silver City High School, he went on to Harvard College, earning a degree in government, and then to Stanford Law School, where I also should note that he met and married his wife as a fellow student, who is an accomplished lawyer in her own right, having had a career in the antitrust division of the U.S. Department of Justice. They have one son. After law school, Jeff worked as an assistant attorney general and then spent 8 years in the private practice of law in Santa Fe before running for and being elected attorney general of the state of New Mexico. And then following that, he was elected for the first time in 1982 to the United States Senate and served 5 terms, 30 years as a senator in D.C. He, at the time of his retirement, was chair of the Energy and Natural Resources Committee. He also served on the Finance Committee, the Health, Education, Labor, and Pensions Committee, and the Joint Economic Committee, covering a broad spectrum of domestic policy in Congress, in the Senate. He's also, since retiring from the Senate, spent a year as a distinguished fellow at the Taylor Center for Energy Policy and Finance at the Stanford Law School, his alma mater. He's also, following in his folks' footsteps, taught a seminar on the function of Congress. I think we'll hear more about that at the Honors College at the University of New Mexico. Both he and his wife currently reside in Santa Fe, and we are just thrilled to have you here, Senator, to enlighten us on how we're going to bridge this, dare I say it, hyper-partisan divide in Congress. Thank you.
Well, thank you very much for the kind introduction and the invitation to be here. And let me start by thanking Robin Craig, who was the first to suggest that maybe I ought to come up here and talk. She and I were had fellowships at the Bellagio Center in Italy a year and a half ago or so, and that's where we got acquainted. I thought I'd talk today about the breakdown in governing norms in Washington. And before I get far into it, I'll try to define what I'm talking about. We're all familiar with the concept of social norms. Social norms are, according to the dictionary, the informal understandings that govern the behavior of members of society. And they give a bunch of examples. One example is that when you arrive at a restaurant or at a movie theater and there's a line of people there, you go to the back of the line. You don't go to the front of the line. So that's a social norm. Another social norm is that if you're going to be very late for an appointment, you're supposed to call ahead or send a text message or some way or other advise them that you're not on time. All of this comes under the heading of civility. When we use that term civility, I think we're generally talking about social norms. We're not as familiar with the concept of governing norms. I define these as the informal understandings that govern the behavior or interaction of governmental institutions. And in this talk, I'm going to particularly focus on the interactions and behavior of the Congress and the President. The governing norms are not constitutional requirements. They're not even statutory requirements. They're not even rules that have been formally adopted by these institutions, but they, like social norms, they are informal. They are understandings about how these institutions are supposed to interact and do the public's business. So the overall theme of this talk is that we've seen a breakdown, we continue to see a breakdown in these governing norms in Washington. But there are solutions which are available if we just step up and adopt them. There are several examples that I could discuss. I'm mainly going to talk about two examples, two practices or tactics that have come into regular use in recent decades, and in fact that came into regular use when I was in the Senate. Both tactics are contrary to the governing norms that have prevailed during most of our nation's history. The first I want to talk about is the shutting down of the government, and the second I want to talk about is threats by Congress to default on the national debt. I'm persuaded that the people who wrote our Constitution, the Founding Fathers, would have considered the use of either of these tactics, shutting the government or threatening to default on the debt, as an abuse of the powers that were granted by the people to the Congress and to the President in the Constitution. So first, talking about shutting the government. In order for the government to function, of course, Congress, together with the President, needs to enact legislation to provide the funds to pay for the government. Article 1, Section 9, Clause 7 of the Constitution provides, quote, "No money shall be drawn from the Treasury, but in consequence of appropriations made by law." The governing norm over most of our nation's history has been for Congress and the President to support maintaining a functioning government. The normal way to maintain a functioning government is to enact appropriations bills on an annual basis. But history has proven that that's not always that easy to do. It's hard to get the House and Senate to agree on exactly what should be in an appropriation bill. It's hard to get the President in agreement so that he'll sign the bill once it's sent to him. So the solution that they've come up with, and this has been in place for decades now, the solution has been to pass continuing resolutions. These are short-term spending bills that essentially maintain current funding levels until Congress can agree on something that's more acceptable to both sides. And it's become commonplace for Congress to enact and for the President to sign at least some of these continuing resolutions every fiscal year. That was the governing norm when I first got to the Senate in 1983. Howard Baker, the Republican majority leader at that time, Robert C. Byrd, the Democratic leader from West Virginia, they were agreeable to signing these continuing resolutions or enacting these continuing resolutions, and neither they nor Tip O'Neill, who was Speaker, nor President Reagan were threatening to shut the government in order to gain leverage in these negotiations about what ought to be in longer term spending bills. They all agreed that when they couldn't agree on long-term policy, they at least would agree to keep the government functioning. But that was 1983. In 1995, that changed. 1994, the election in 1994 gave Republicans control of the House, and their first official act, of course, was to elect a speaker, and they elected Newt Gingrich. The election of Gingrich set the stage for confrontation with President Clinton later in 1995, and the dispute centered on funding levels for education, for the environment, for public health issues, for Medicaid. These were all programs that were important to President Clinton. They were all programs important to Democrats in the Congress. So when negotiations between the President and the Congress on those funding levels broke down, the House made a decision not to enact a continuing resolution. And that was an important decision. It amounted to a decision to shut down the government. On November 14, major portions of the government did shut down. That shutdown only lasted 5 days. Then the House relented and went ahead and passed the short-term bill that the President signed. But when that expired, and no agreement had yet been reached between President Clinton and Republicans in the Congress, a second shutdown occurred. That one went from the 16th of December till the 6th of January. The explanation for the shutdowns was made clear by Speaker Gingrich in a statement that was quoted in the Wall Street Journal. This was on December 20th of 95, and he said, that was the key strategic decision that was made on election night a year ago. If you're going to operate with the president's veto being the ultimate trump, you have to operate within a very narrow range of change. So you had to find a trump to match his trump. And the right not to pass money bills is the only trump that is equally strong. So in January, 2 months ago, Gingrich was asked in an NPR interview if he had any regrets about his decision to shut the government in 1995. He stated he had no regrets, that in his view, shutting the government was part of the American system. Let me put a chart up here that just sort of shows you the history we've had of some of these shutdowns. I've discussed the one in November of 95 and the one that began in December of 95 and ran into January of 96. The 2013 shutdown was an effort by the Republican-controlled Congress to block the implementation of the Affordable Care Act. It lasted 16 days, according to this chart. There was a 3-day shutdown last year in 2018. Democratic members of the Senate were responsible for that. They were trying to negotiate some protection for dreamers in the immigration negotiations with President Trump, and they refused to vote for a continuing resolution for a 3-day period there. The 35-day shutdown that we just experienced that ended in January, started in December, ended in January, that of course was an effort by President Trump to force Congress to provide $5.7 billion to build a wall on the U.S.-Mexico border. I believe I'm right that this is the first time in our history where a president has initiated a shutdown of the government in order to put pressure on the Congress instead of vice versa. I strongly disagree with Speaker Gingrich's suggestion that there's anything normal about refusing to fund the operation of government. He's right that in recent decades, shutting the government has become part of the American system. And he, in my view, deserves much of the blame for that. But this is not the governing norm. This is not what has prevailed during most of our history. During most of our history, shutting the government was not a normal way in which Congress and the President went about doing the business of the country. So what's the solution to this? To get us back to an understanding that members of Congress and the President have an obligation to maintain a functioning government, I would favor replacing the governing norm that has now broken down, with legislation to provide that when a funding bill expires, there should be an automatic continuation of funding at then existing levels until Congress enacts a new funding bill. If they want to cut funding in the new funding bill, that's certainly acceptable, but they should not just be able to go without any funding level for the government. There are two bills pending in the Senate today that would accomplish this. One was proposed by Senator Rob Portman of Ohio, the Republican, the other by Senator Mark Warner of Virginia, a Democrat. Senator Warner's bill seems to me to make the most sense. He's titled his bill the Stop Stupidity Act. And stupidity, like a lot of bills in Washington, it's intended to be an acronym for a much longer title. The longer title is the Stop Shutdowns Transferring Unnecessary Pain and Inflicting Damage in the Coming Years Act. Several people have pointed out that if you take the first letter of each of those words in the long title, you don't come up with Stop Stupidity, you come up with Stop Stupidity Act, the Stop Stupidity Act. So, but at any rate, whatever Senator Warner's bill or Senator Portman's bill, in my view, would be a substantial improvement over what we currently have. If legislation such as this cannot be enacted, then the second best solution is to persuade everyone involved that shutting the government will not work to their advantage. And the only way to do that is for everyone to agree that regardless of what issue is in dispute between the Congress and the President, negotiations to resolve the issue will cease during any period in which the government is not funded. That's essentially what Nancy Pelosi and Chuck Schumer did in the last shutdown. Let me give the last word on this issue to my friend Lamar Alexander from Tennessee, and he is a friend. He was quoted in the New York Times a few months ago saying the following. He said, "Shutting down the government of the United States of America should never, ever be used as a bargaining chip for any issue. Period. It should be to governing as chemical warfare is to real warfare. It should be banned. It should be unthinkable." And I agree with Senator Alexander's view. We should once again make his view the governing norm on the issue of maintaining a functioning government. So let me go on to the second example I was going to talk to you about. That's refusing to permit borrowing. Here again, we have a breakdown, in my view, in governing norms at the federal level. Here I'm talking about the tactic that was used by Republican congressional leaders in negotiations with President Obama. The tactic is to threaten default on the national debt by refusing to raise the debt ceiling. Now, as a matter of arithmetic, Congress determines the amount of borrowing that's required when it enacts the tax laws and when it enacts the spending bills. If Congress wants to reduce the need to borrow, it can raise taxes or it can cut spending. I mean, that's just the logic of it. But in spite of this reality, many decades ago, Congress determined that it wanted to enact a statutory debt ceiling. The first debt ceiling was enacted in 1917. 22 years later, in 1939, Congress enacted the first limit on total accumulated debt. Now, this ceiling or limit on debt has never limited the ability of the government to incur obligations. It merely limits the ability of the government to pay for the obligations that it's already incurred. For politicians, the issue of the debt ceiling has proven to be an impetus for substantial demagoguery. And for voters, it has been a source of substantial confusion. A vote to increase the debt ceiling is interpreted by many voters as a vote for more debt. In reality, the votes in Congress that result in more debt are not the votes to raise the debt ceiling. Instead, they're the votes to cut taxes or to increase spending. And this confusion causes politicians who want to appear fiscally conservative to vote against increasing the debt ceiling, even though they may have strongly supported the legislation, that is, the tax cuts or the spending increases that have resulted in the need to raise the debt ceiling. Since the debt ceiling was first enacted, it's been raised many times. Now here I've got another chart to show you. Democrats and Republicans have participated in raising the debt ceiling. From 78 to 2017, Congress raised or suspended the debt ceiling 57 times. This chart shows the history of debt ceiling increases during the terms of each president, from President Truman through President Obama. Now, the chart does not reflect recent changes in the language that Congress uses to discuss the issue. At the time I was in the Senate, during the full 30 years I was there, we just voted on raising the debt ceiling. A few years ago, Congress began enacting provisions to suspend the debt ceiling. And I assume some pollster advised them that it sounded less irresponsible to suspend the debt ceiling than it did to raise the debt ceiling. Of course, there's no substantive difference between the two, because each act to suspend the debt ceiling contains language that automatically raises the ceiling by the amount that the Department of Treasury has had to borrow by the time the suspension expires. During my first 38 years in the Senate, the leadership, both Democrats and Republicans, followed a well-understood procedure for, or governing norm, I would call it, which applied to needed increases in the debt ceiling. First, the Secretary of Treasury would notify Congress of the need to raise the debt ceiling and the date by which the increase had to be enacted. Second, the congressional leaders would settle on how much of an increase they would propose to the two houses of Congress. And then, after various speeches about the need to rein in spending and reduce the deficit, both houses of Congress would muster the votes needed to enact the increases. I remember I had a conversation with Senator Jim Exon. Jim was a former governor of Nebraska and Democratic senator from Nebraska during the time I was in the Senate. And we were talking about the debt ceiling one day at a lunch, Democratic senators in the Mansfield room there on the second floor of the Senate. And with a twinkle in his eye, Jim said, "My record of votes on increasing the debt ceiling has been totally consistent during my time here in the Senate. When the president requesting the increase is a Democrat, I vote for the increase. When the request comes from a Republican president, I let the Republicans vote for the increase." And when I look back on my own votes on debt ceiling increases, they probably follow a similar pattern. But implied in Senator Exon's statement was a recognition of an understanding that it was not acceptable for Congress to just refuse to raise the debt ceiling. That was the governing norm which prevailed for a very long time. Both parties recognized that the Secretary of Treasury had to have the borrowing authority necessary to meet the obligations that it, the Congress that is, and the President had undertaken. So the only real question was which party was going to be responsible for putting together the votes to increase the ceiling. This recognition of congressional responsibility seemed to evaporate after the 2010 election. In 2011, the new Republican majority in the House determined to use the threat of not passing a debt ceiling increase as a way to force President Obama to agree to substantial long-term cuts in federal spending. And this came to a head in 2011 with the debt ceiling crisis. That was the only time in our nation's history that the credit rating of U.S. bonds was lowered. At that point, President Obama and most Democrats in the Congress, including myself, made what I now consider to have been a mistake in agreeing to negotiate for a resolution of the impasse. And the end result of the confrontation was enactment of the Budget Control Act. Most of that act was misguided, in my opinion, but it did include a provision that had merit. Under the act, the debt ceiling was increased immediately by $400 billion, but in order to get the additional $500 billion that was required, a new procedure was devised, and under that procedure, the President would make a formal request for the additional borrowing authority. Request would automatically be considered approved after a certain period of time unless a resolution of disapproval was passed by both houses of Congress and signed by the President. So this method of raising the debt ceiling had the advantage of giving Republican members of Congress and all members of Congress political cover. They could continue to denounce the President for increasing the debt ceiling, or the other party for increasing the debt ceiling. Although they were not increasing the debt, they were just increasing the debt ceiling. They could also assure voters that they had not been willing to agree to it. Senator McConnell is credited with having devised this procedure. It was dubbed at the time the McConnell mechanism. And the Republican success in this confrontation with President Obama emboldened them to engage in similar threats in the future, as they did 2 years later in 2013. In 2013, we had a combined government shutdown and a threatened default on the debt in order to try to prevent implementation of the Affordable Care Act. So speaking about the 2011 threats, in an interview with the Washington Post, Senator McConnell said, "I think some of our members may have thought the default issue was a hostage you might take a chance at shooting. Most of us didn't think that. What we did learn is this: it is a hostage that's worth ransoming." So where does the debt ceiling issue stand today? In February of 2018, the Congress passed and President Trump signed a law suspending the debt ceiling until March 1st of this year, 4 weeks ago. On that date, a new debt ceiling automatically became what the debt had grown to by that date. That is over $22 trillion. And since March 1st, the national debt has exceeded that debt ceiling. Beginning on the 1st of March, the Secretary of Treasury has not been able to do additional borrowing, but instead has been limited to what are called extraordinary measures to avoid defaulting on the debt. The expectation is that his ability to keep the government from defaulting in this way will end in about September of this year. And at that point, Congress will either have to suspend or raise the debt ceiling again. And my guess is that they will suspend the debt ceiling again, and they'll do so for a long enough period to get us past the 2020 election. The anticipated consequences of failing to act are so adverse that nobody expects a default to occur this fall. However, in light of the statement that I quoted here from Senator McConnell, I do think a future Democratic president might well face threats of default similar to those that were faced by President Obama. So what's the solution to this, the breakdown of this governing norm? In my view, the best course would be to enact legislation to implement something like the McConnell mechanism that was used in the Budget Control Act for all future debt ceiling increases. This is probably too much to hope for, but that would be a permanent solution to the problem. The second best solution is for future presidents to refuse to negotiate with the Congress for debt ceiling increases, just as President Obama refused to in 2013. Faced with that refusal, Congress will almost surely choose not to default as they did in 2013. And if members are willing to default on obligations the government has previously incurred, the appropriate remedy has to be with the voters at the next election. All right, let me, those are two examples that I experienced in the time I was in the Senate, shutting the government, threatening to default on the debt. They are both examples of governing norms breaking down. Since I left the Senate in January of 2013, there have been some additional examples of government norms breaking down. One such example, again in my view, is the refusal to allow a hearing for President Obama's nominee to the Supreme Court. In 2016, the Republican majority in the Senate determined not to allow a hearing for Court of Appeals Judge Merrick Garland, who President Obama had nominated to the Supreme Court. On February 13, Justice Scalia died. This is all in 2016. 10 days later, on February 23rd, before the president had even nominated a replacement, Republican members of the Judiciary Committee wrote to the Senate Majority Leader stating that they would not agree to consider any nomination that President Obama might make to fill the vacancy. They made clear that no hearing would be held to fill the vacancy until the next president was elected and sworn in some 11 months later. So on March 16, President Obama went ahead and nominated Judge Garland to fill the Scalia vacancy. The Republican majority in the Senate were good to their word. They did not hold a hearing or otherwise consider the nomination. And the nomination was before the Senate for 293 days. That's the longest period for any Supreme Court nominee in the history of the country. In August of 2016, Senator McConnell was interviewed about this. He said, this is a quote, "One of my proudest moments was when I looked Barack Obama in the eye and said, 'Mr. President, you will not fill the Supreme Court vacancy.'" To my mind, the refusal to consider President Obama's nominee was totally without precedent. It was a refusal by the Senate to carry out one of its core responsibilities under the Constitution. It was an abuse of power, and it was clearly a breach of the governing norm that had been adhered to by the Senate in the case of Supreme Court nominees since the country was founded. This breach of governing norms is not that easy to repair. Now that a Republican-controlled Senate has refused to consider a Democratic president's nominee to fill a vacancy, there will be an expectation on the part of many that when the Senate is once again controlled by Democrats, a Republican president might also be denied the right to fill a Supreme Court vacancy during his or her last year in office. That circumstance may not arise for a while, but unfortunately, a bad precedent such as this can have a very long half-life in the U.S. Senate. So the final example I wanted to mention of a breakdown in governing norms is President Trump's decision to declare an emergency in order to use funds appropriated for other purposes to construct a border wall. In voting against the president's action, Senator Portman explained the issue well. He said the use of emergency powers to circumvent Congress's explicit decision on funding is unprecedented. No president has ever used what's called the National Emergencies Act in this way. As a result, it opens the door to future presidents to implement whatever policy they want and to use funding from other areas that Congress has already decided on without Congress's approval. This final example, of course, there's litigation to establish that President Trump's use of emergency powers violates both the National Emergencies Act and the Constitution. But whether those suits are successful or not, his actions, in my view, clearly violate the governing norm that has applied to the use of presidential powers, presidential emergency powers. Both the House and Senate passed a resolution disapproving the president's declaration of emergency. That resolution of disapproval was vetoed by President Trump. So 2/3 of each house would have to override the veto, and on Tuesday, 2 days ago, the House demonstrated that 2/3 of its members are not willing to override the veto. I would doubt seriously that it'll even be brought up in the Senate. The American public is rightfully concerned about dysfunction in the government, and I share that concern. A major part of that dysfunction, in my view, is this breakdown of governing norms that I've discussed. I believe that through the kinds of actions that I've outlined, it is possible for us to get back once again to adhering to the governing norms that have prevailed during most of the nation's history. I also believe it's very important for the country that we try to do so. Thank you very much. If anyone had a question that they wanted to ask or a comment or a statement, please.
What role do you think in creating and continuing this dysfunctional Congress does the fact that congressmen now are flying home, 3 or 4 day weekends instead of staying and socializing and getting to know their colleagues?
Well, I think that is a factor. I do think that just as the country is very polarized, I think the Congress itself is very polarized, and the opportunities to build bridges across party lines and build alliances with people of the other party is not what it once was. There are a great many other factors, though, as well. I mean, I think that the Congress reflects the polarization that has settled into the entire country. On Supreme Court packing? Well, I would not favor trying to add additional members to the Supreme Court. I don't think that's a long-term solution that makes any sense. FDR obviously tried it and was unsuccessful, and I think may have regretted having made the effort. So I don't really think that's a long-term solution.
Would you describe cloture as a governing norm, and do you see the erosion of that as another similar threat?
Well, of course, cloture is the procedure that you use to cut off debate in the Senate, and it only applies in the Senate. In the House, it doesn't apply. But in the Senate, the general rule is that you have unlimited debate and unlimited ability to offer amendments. And the procedure in Senate rules for dealing with that unlimited debate is to allow a filing of a petition for cloture, and if you can get enough senators to vote for it, you can cut off debate. I don't think that the cloture process itself is a particular problem. I mean, there are suggestions for ways to modernize that. And I really don't think, I'm not one who favors eliminating the right to filibuster. I think there's some value in having that opportunity available where, as long as the right to filibuster is not abused in the process. There were periods during the time I was in the Senate where I felt that the right to filibuster was being abused. It was being used too much. It was not being used to make principal stands on major issues. Instead, it was being used to prevent the Senate from doing its normal work. Again, I think that's one of those social norms, or one of those governing norms, that it would be good if we had agreement among the leaders of the two parties there in the Senate as to the types of circumstances in which filibuster is appropriate.
So, one of my biggest concerns now is we want to get back to established governing norms.
Right.
We need both sides to agree that that's the right goal. What if, one of the sides, I don't want to make this partisan because I have my own political views, but one side feels like it's losing its base number-wise, while the other side is growing. So they see it as a zero-sum game. And they feel like it's the only way to move forward while protecting their interests is to move away from these governing norms. So how do you respond to that in a way where one side, maybe trying to move toward those governing norms, is willing to give, while the other side is not willing to give? How do you address that?
Well, that's a very, very difficult question. Whoever is an elected official obviously wants to try to do what is desired and demanded of them by the people that elected them. So their political base, so to speak, they're trying to stick up for them and implement policies that their supporters would support. I do think that that's always been the case. That's just a part of the of politics and government. So I think that the fact that one party is waxing and the other party is waning as far as the size of their base, I don't really think is a justification for abandoning or discarding or overriding the governing norms that we have traditionally relied on. That's my own view. I just think that if in fact the Senate is not going to have to consider nominees for the Supreme Court if they are made by a president of the other party, the system breaks down, as I see it. Yes?
I think the situation has become quite different because of the discipline of the two parties. They now are much more disciplined than they ever were in the past. And particularly, and I think I think norms are very hard to accept, and I think they serve, and they can easily be abandoned. So sometimes you need to change rules. So we note that nearly any president will have 2 years for his legislative agenda, or her legislative agenda, and then after 2 years, Congress, the House, will at least shift back. So that's happened. So you only get 2 years, and then you get maybe 6 years and nothing happening. So, which is one problem, whether terms should be amended to the Constitution to have a 4-year House term, so you have more time to realize your agenda. But then the other side is, I don't think the 2-term limit on the president has actually been useful. because that means you're lame duck for the second term, which means, of course, you're going to be able to say, let's delay a Supreme Court nomination because there's no risk of that president coming back. So I guess my main question is, if norms simply serve the politics of the moment, maybe we need to change by constitutional amendment the rules of the game.
Well, it's possible that we do. I suggested in here a couple of legislative fixes for the breakdown of governmental norms, and I agree with you. Government norms are much easier to sidestep or ignore than a statute would be. I don't really know what constitutional amendments. Your suggestion about a 4-year term for members of the House is something I think makes good sense. I think that's one of the mistakes that the founding fathers made when they wrote the Constitution, because they're in a permanent campaign in the House. They're always running. I got a call 6 weeks ago from a congressperson who had just gotten elected for the first time, asking me to make a contribution to her for the next election. And I said, is there anybody indicating they're going to run against you? And the answer was no. And I said, well, why don't we wait until you've got an opponent, or until someone's indicated they're going to be an opponent, and then give me a call, because I'm glad to help. But but it's a permanent campaign for House members, and going to a 4-year term would help fix that. Yes?
Did you ever give this speech to Congress?
Well, I'm sure that there are various people in Congress who have similar thoughts, and as many who have contradictory thoughts. But I agree, they're the ones that ought to focus on it. They and the president both. Yes.
Why Congress is unwilling to fund Medicare as it stands today. I mean, to expand it to the entire country, but they're unwilling to fund the current program seems absurd.
Well, I think I don't know when Medicare is expected now to become insolvent, but it's quite a ways in the future.
Every day we wait makes the final hurdle higher.
Well, that's true, and it's very possible that Congress should go back and adjust the amount that is raised for Medicare to solve that problem. I mean, the truth is we have loaded more and more onto Medicare, and we have not raised the dollars necessary to pay for it. I mean, when President George W. Bush was in office, one of his great accomplishments was adding the prescription drug benefit. There was no pretense about paying for that. It was just added on. And there was no provision made for, and that's the kind of thing that I think has made it difficult to ensure the long-term solvency of Medicare. Yes, Bob.
So, from your perspective as a former legislator, just to change directions just a little bit, over the last 20, 25 years, the Supreme Court has struck down more frequently legislation adopted by Congress than had been the case or the norm in the past. From your perspective as a legislator, could you comment on the relationship between Congress and the court? Is there an ongoing dialogue between the two? Do they exist in a vacuum? Could you offer some observations again?
Well, I think they generally exist in a vacuum. That's my observation. That may be wrong. There may be some people in the Congress who are talking to members of the Supreme Court, but I certainly was never one of those. And I do think that one of the things that amazed me, I was very involved with the drafting of the legislation that went through the Senate to adopt the Affordable Care Act. And I must have attended 50 meetings where we talked about different provisions of the law and possible problems with different provisions. And there was no time in any of those meetings that anyone ever raised the possibility that Congress did not have the legal authority to require states that wanted to participate in the Medicaid program to increase the eligibility rate, the eligibility age, the income limit for adults. It was never raised as a possibility, and of course that's what Justice Roberts latched on to basically say that the provisions in the Affordable Care Act that required states to increase eligibility were, in his view, unconstitutional. So there's a real breakdown there. We had good lawyers advising us. We had a lot of smart people who knew a lot about health care and other issues as well, but nobody anticipated that this would be a problem in the Supreme Court. At least I never heard anybody voice that view. So I don't know how you get around that. I don't know how you anticipate potential problems and get them corrected before they happen, but that's been a very unfortunate deficiency in the Affordable Care Act as interpreted by the Supreme Court. And you've got a lot of states out there that have not expanded Medicaid because of that. Yes? Well, if I had the answer to that, I'd run for president myself. I'd be number 68, or however many candidates there are on the Democratic side. I don't know the answer, but thank you again for inviting me. I appreciate it very much.
Thank you all for joining us. We will reconvene with our regular greenbacks in the fall, and I mentioned the Conservation Easement Tax Policy Program in early May. Information available on the join me once again, please. Thank you. Probably get some questions.
told me he was going to pick
He's
me
pick
up.
you up, okay.
Thank you
Sure,
again for
sure.
being here.
No,
Great to
thank
see
you
you again.
for all
It's
that.
my best to
Okay, I'll tell her.
thank you for bringing thought and reason to these issues. We hear so much rhetoric around these issues, and that was just really thoughtful. I appreciate it.
That's great.
I really enjoyed listening to you. Very informative, thoughtful. Thank you so much. I'm glad I came.
How you doing, kid?
Fine. Did you get enough lunch?
Yeah, how about yourself?
Oh, no, I never expected
He's going to Italy next week.
Just for vacation.
that. Oh, yeah? Where are you going?
Amsterdam, and then Berlin, and Brussels.
And what kind of vacation?